Hey there. I am going to be talking about the elephant in the room, which is all new paperwork that was initiated as of August 1st, 2024, as a direct result of the class action lawsuits and NAR settlement agreement. And so there is a lot of confusion in the industry. All the forms are new. It's good. There's going to be a learning curve in it, especially putting it into practice. But I do want to take a couple of minutes and just make it simple, right? I think people are they're more nervous and freaked out about these changes than being level-headed. Okay, and so I understand them. They're clear. It really is clear as long as we use the right paperwork. There's a couple of forms that are optional, and the way I'm going to show it is the way that I will present with all buyers. This way, there's no confusion. There's no confusion on concessions that are allowed per your lender. Okay. When I say concessions, I'm talking about concessions that the seller will give to a buyer to maybe help to buy down an interest rate or pay closing costs. Okay. But the other concessions that could be included are compensation. And this way, the way that I propose to write up paperwork and the forms that I propose to use, we won't ever be in a situation where we are mixing the compensation and the concessions, because I always want to be able to get you as a buyer the maximum concessions that you need to be able to pay your closing costs and or is allowable by the guidelines of the loan type that you are going to be getting. So the way that I'm going to show, I'm first going to go over the buyer broker exclusive employment agreement, which is a form that's been changed and is now required. Okay. Previously, people didn't, a lot of realtors didn't have their clients sign this paperwork because it was an uncomfortable conversation to have for realtors that didn't feel strong in their position yet with their prospective client. Okay. I used it quite a bit, but not all the time, because a lot of the time people that were coming to me were referral or repeat business and they weren't going anywhere else. Okay. If I ever had a question on the loyalty of a buyer or something like that, though, I always would use this. So in any event, right now, we're going to go over this. This is 3 pages. And then I'm going to show you the next form, which is the SCA or seller compensation agreement that would accompany a purchase contract this way. And I'll explain it all. Okay. So buyer broker exclusive employment agreement. First thing that I'm going to notice is right up here. It says notice to buyer. All realtors are required to have a signed written agreement prior to showing a home to a buyer. Now, this is in direct response to the NAR settlement, okay? And so it is required. Now, first offense for a realtor showing a home without having a properly disclosed and signed agreement up front is a $500 fine by AAR, and then the next one is $5,000 up to $15,000, and could lose 30 days. The next occurrence could lose 30 days access to the MLS. So those that have implemented these changes are serious about making sure that all realtors and brokers abide by these changes immediately. Okay, and so up here, buyer shows the potential buyer. Broker is the broker's name. Agent, if there's more than one agent, their name's here. Line 4, the agreement is between the buyer broker exclusive employment agreement is between the buyer and the broker in consideration of broker's agreement to assist buyer to locate, negotiate, and facilitate the purchase of a property. Buyer gives broker the exclusive and irrevocable right to represent buyer in the purchase of a property during the term. Buyer acknowledges that signing more than one buyer-broker exclusive employment agreement or similar agreements could make the buyer liable to compensate multiple brokers. That's very important that you understand that. Okay, and then nine leaves the term of the agreement, when it shall commence and when it shall expire. And then for the purpose of locating the residential property, land, commercial, and then to negotiate at buyer's direction to obtain acceptable terms and the conditions for the purchase, exchange, or option of the property. Assist buyer in during the transaction with the scope of broker's expertise and licensing. Number 17 is to choose an agency relationship, which I always choose 18, which is as set forth in the real estate agency disclosure and election, which we refer to as a READY. Okay, and property viewings, buyer agrees to work exclusively with broker to be accompanied by broker on buyer's first visit to any property. If buyer does not accompany buyer on the first visit to any property, including a model home, new home lot, or open house by a builder, seller, or other real estate broker, buyer acknowledges that the builder, seller, or seller's broker may refuse to compensate broker, which will eliminate any credit against the agreed upon broker compensation below. That is true. All builders have a signage in front before we all enter that says a real estate professional must accompany you on your first visit. And so it's very important that if you're choosing to work with a realtor, that you do work with them the entire time. And then 24, buyer agrees to review the Arizona Department of Real Estate buyer advisor to assist in buyers inspections and investigations. That's a great form. 25, broker compensation is not set by law nor any board, association of realtors, multiple listing service, or in any manner other than as usually negotiated between broker and buyer in this agreement. This is reiterating what's always been. There's no set standard amount, and all compensation is negotiable between the parties. Previously, it was that the seller was establishing how much they were going to pay upfront, and it would go into the MLS. Part of the new law and rule that NAR agreed to is that we wouldn't post compensation to a buyer broker in the MLS. That does not mean that a seller cannot offer it. It just means it can't be put in the MLS. It definitely isn't as clear as it used to be, but this is why it's also very important to work with someone that knows the paperwork, knows the ups and ins and outs of the entire transaction, and won't get yourself in a pickle. The next line 28 addresses retainer fees, and some people would choose to take a retainer fee upfront. That kind of just would hold. It really makes a buyer real, right? And then when they've written a check upfront to the broker, they really are agreeing and committing upfront to be working with that person exclusively. And then down below here, it says broker compensation. If buyer, or any entity owned or controlled by buyer closes escrow on a transaction for the purchase, exchange, or option of a property, buyer agrees to compensate broker as follows. And this is where the fee that is negotiated will be put in, either a percentage of the total purchase price, a flat dollar amount, or an other, which I was not sure what the other would be, but anyway, that's what that is. Broker compensation shall be in U.S. currency and paid at the time of and as a condition of closing for purchase or exchange, or as otherwise agreed upon in writing. Okay, now compensation from seller or seller's broker. This is where we are talking about the next form, okay? What we're talking about here applies to the next form. So this says compensation from a seller or seller's broker. Seller or seller's broker may offer compensation to broker. Buyer authorizes broker to accept compensation from seller or seller's broker, which shall be credited against broker compensation. So if the seller initially upfront says, hey, listing agent, we're paying you X amount, and we'll agree to pay 2% to a buyer broker. Okay, that doesn't go in the MLS, but the listing agent has that close to his sleeve where he can disclose that to prospective buyers agents should they inquire about that. Okay, what I'm saying is the best practice, though, is to just leave all compensation into negotiation when we are writing an offer. Okay, so instead of looking at homes that are only offering compensation up front, and the reason why we don't want to do that is because let's just say a seller says, oh, I don't have to pay a commission now to a buyer's agent. And then they list the house at 100% of retail, okay? And 40 days goes by and they haven't shown that house to anybody. And then you and I are on the MLS looking at homes, and I say, hey, let's go take a look at that place. That house hasn't been sold in 40 days. It looks like they're asking retail for it, and they're probably not showing that they're really willing to play ball. But we go out there and then we write an offer that, when presented to the seller, just makes sense, even though it includes compensation. And so I think it's best practice to be able to show you all the homes in that are on the market for sale, and then let's negotiate just like we always have negotiated. Okay, and let the chips fall where they may. That does not mean that I would go show you a property that will not agree to pay compensation and then go under contract on that if they will not agree to compensation. So we are going to negotiate that. And if they don't agree to it, then we cut bait. Okay. But going in the entire time, my idea is everything's negotiable. It always has been negotiable. Okay. And so it's just business as usual. If the seller or seller's broker offer of compensation is greater than the broker compensation, broker shall be paid the broker compensation, and the balance shall be credited to the buyer to the extent allowed by the buyer's lender. Broker will not receive any amount greater than the broker compensation from any source for services provided in this agreement. So what it's saying is, once this is established, this is what it is. Okay. If the seller, when you find a house that the seller was going to pay 3% on, and we had agreed at 2.5%, there's an extra 0.5%. That's going to go back to you to pay your costs, as long as there is enough room in the guidelines with your lender to apply those monies to your closing costs. Okay, if seller or seller's broker offer compensation, we just went over that. This next thing talks about VA financing. VA has lifted their restriction on buyers paying the fees temporarily until they make their changes to their guidelines. And then failure to complete. Once an acceptable property is located, buyer agrees to act in good faith to acquire the property and conduct inspections, investigations of the property that buyer deemed material and or important in completion of any transaction is prevented by buyer's breach or with the consent of buyer other than as provided in the purchase contract, the broker compensation shall be due and payable by buyer. Okay, so this is basically saying, if we bring a ready, willing, and able buyer, and then everything is satisfied, and then at the 11th hour, the buyer says, I'm not going to do the transaction, then they're on the hook potentially to be paying that compensation to their agent. Compensation after expiration date, line 53, says after the expiration date of this agreement, buyer agrees to pay broker compensation if within blank calendar days after the expiration date, buyer enters into an agreement to purchase, change, or option any property shown or negotiated by broker on behalf of the buyer during the term of this agreement, or buyer closes escrow on a property pursuant to a purchase contract that was executed during the term of this agreement, or buyer closes escrow on a property for which escrow was open during the term of this agreement. So basically, this is just a CYA for agents, so that maybe someone that they've been working with for some time or will be working with some time doesn't go ahead and circumvent them, you know, saying, hey, well, my agreement ends with this agent in 10 days, and then I can agree for 10 days. Believe me, it happens. it happens, and that's why stuff like that is in here. Most people are, don't do this, but there are those instances where people are cutthroat and would try to, you know, be greedy in that position. Listings, broker shall show property listings that fit buyer's criteria, regardless of the compensation offered to broker by seller or seller's broker, unless instructed otherwise by buyer in writing. Is, if necessary, buyer instructs broker to negotiate broker compensation to be paid by seller or seller's broker. These net negotiations shall not jeopardize, delay, or interfere with the initiation process or finalizing of a transaction. Okay, so what this is referring to is, once again, there are two forms that could be used. There's the CAB, okay, which is, it's one that I will elect not to use, because that one limits, or it gets credited against the total concessions that a lender will allow you to use. And that has to be signed before a offer can be presented. I don't ever want something that would stop the flow of our paperwork being delivered in making an offer. Okay, so that I don't want to have an extra step that I have to have the listing agent sign it and get it back to me before we can present an offer. That is exactly what this is saying, that we are not going to hold up the delivery or negotiation because of compensation. So what we do is we use the SCA, which I'm going to get to now, and the SCA is a seller compensation agreement. Is basically us saying the buyer is asking the seller to pay the buyer's cost as a condition of closing escrow. Okay, so I did. Okay, it says if buyer decides they do not wish to view properties listings unless the seller or seller's broker has offered adequate compensation to broker, the buyer must make this instruction to broker in writing. Folks, what I think is going to happen anyway, I think that a lot of sellers are going to find out really soon that just because of that their understanding of the settlement is not what the reality of the settlement is. It's all a negotiation. It always has been a negotiation. The only thing that's changed is that the seller doesn't determine upfront how much the buyer's broker is really getting. That's between the buyer broker and the buyer. That's all there is to it. Okay. It says other potential buyers, buyer consents and acknowledges that there are other potential buyers represented by the broker may consider, make offers or acquire an interest in the same property. Just saying that I could be working with another set of buyers on the same house, or another agent out of my office could be working with another buyer for the same house. This release of broker acknowledges, agrees that broker is not qualified nor licensed to offer advice on financial, legal, tax matters regarding real estate transactions, related services. Broker, if requested, may provide buyer the names of third-party professionals who claim to perform related services. Buyer is instructed to independently investigate all potential third-party professionals and use their sole discretion in selecting which third-party professionals to hire. If any buyer expressly releases, holds harmless, and indemnifies broker from any and all liability and responsibility regarding buyer's selection and use of third-party professionals to perform related services or buyer's elections not to use the services of such third-party professionals. Basically, like, I've got a list of vendors that I use, trust, and know, but I can't guarantee that they'll answer the phone, that they'll show up on time, that the workmanship, right? So it's just saying I can give you references, but I can't guarantee, and I've got to be held harmless for those references, and it's up to you to do your own due diligence. Then this one, number 81, is talking about alternative dispute resolutions. This is new. This is talking, well, there's always been an agreement to resolve any disputes by mediation. But further on in this, it goes on to talk about that you would agree not to join in any future class action lawsuits, and yada yada. This also is a direct relation to the NAR settlement. Okay, so they're getting ahead of it and saying, hey, you agree not to have any future lawsuits or class action lawsuits. You know, we might have that here, but there's no way to stop that. If attorneys wanted to bring up a class action lawsuit, you know, this would be this little blip in the road for them. Attorney's fees and costs that says in any non-realtor association proceeding to enforce the compensation due broker pursuant to this agreement, the prevailing party shall be awarded their reasonable attorney fees and arbitration costs. It says Arizona law governs by jurisdiction, state of Arizona. If you're a buyer from another state and you want to have your attorney look at it, you're more than welcome to do it, but we're not changing this contract. We're not, we're not line striking anything. Our contract is our contract. It's a boilerplate that has spaces to be completed, and that's how we do it. That is how we do it. Copies and counterparts, the entire agreement, and any addenda are attached shall constitute the entire agreement between buyer and broker and shall supersede any other written and all agreements between buyer and broker and can be modified only by a writing signed by buyer and broker. Invalidity and enforceability of one or more provisions of this agreement shall not affect any other provisions of this agreement. Buyer warrants that buyer has the legal capacity, full power and authority to enter into this agreement and consummate the transaction contemplated hereby on buyer's behalf or on behalf of the buyer, the party buyer represents as appropriate. And then buyer hereby agrees that all terms and conditions herein and acknowledges receipt of this agreement. Okay, and then there's a place for everybody to sign. Now I'm going to go over the SCA, which is the other form that would accompany the purchase contract and asking that the seller compensates the buyer's agent or buyer's broker. Okay, so once again, it's back to a negotiation. This is an addendum originated by, we're going to say it's going to be the buyer because we're going to be writing up the offers. This is an addendum to the contract that we were just executing. The buyer's name, the seller's name, the premises. Okay. Following additional terms and the conditions hereby included in the part of the contract or lease agreement between seller and buyer for the above referenced premises. Seller shall pay broker representing buyer compensation as follows. Either a percentage of the sale of the full price or a dollar figure at close of escrow. Once again, it's got to be determined here. Can't be open-ended. And then compensation for a lease. The compensation is in addition to any seller concessions credited to buyer in the contract, if applicable. See, this is what's important. Because if we use the other form, and the other form was asking for 5% in concessions, and the lender is only allowed to use 3%, then we might have just given money away. So we want to separate your concession that you need to close your closing costs and your loan costs, and then use this seller compensation to determine the buyer agent compensation. It's just the easiest and cleanest way that there's no conflict whatsoever. Check if applicable, pursuant to a separate written agreement. Seller broker has agreed to compensate buyer broker in the amount of blank percentage of the full purchase price or the dollar amount, which is independent of and in addition to the compensation in this agreement. The addendum provides the undersigned written consent for buyer broker to receive compensation from more than one party to the transaction. Okay, so in this case, the case that there would be requiring that other form, that CAB, that would be if, let's just say, the first form, that buyer broker agreement was for 3%, and then we sent in this form and the seller countered this form and said they'd pay 2.5%. Okay, that's when we would introduce the CAB, the other form, to bridge the gap for the other 0.5%. But that would go in afterwards and not up front. I just think it's good. I know that would be a concern for muddying the waters. Okay. And then down here is just everybody signing, who you are, your date. I hope this was clear. This was a little bit longer than, it was probably longer than I wanted to spend on it, but this is the most important thing for a buyer as far as changes, okay? And this is super important because you should really know that the realtor that you're working with understands this and understands how you will be formulating an offer so that your best interests are met, okay? Let's just say that, hey, you've got money for your down payment, but you don't have money for closing costs and you don't have money for commissions. I know that going in. That's how I've worked my entire career with the lender. We communicate very clearly and closely, and then I negotiate that. Don't let all this other stuff and these things, the things that the media is talking about and lay people in the street that really aren't in the trenches daily, confuse you on. I'm Andrew Texidor. I've been licensed since 2000. I'm going into my 24th year here in the Valley. I've made a living helping buyers buy homes, and I'd love to help you. I'd count it an honor. I love helping somebody go from being a renter to being a homeowner, and I get joy out of that. It's more work than second time buyers or move up buyers or sellers, but it really is gratifying. Andrew Texidor, if you got something out of this, give me a comment. Let me know what you feel. Share this with somebody that you know. Please do subscribe and give me a call. Let's get you started in the route to home ownership. Thanks for spending a few minutes here, and take care.